Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning. My name is Chris Statham. I've been with the firm Devry, Smith & Frank for a little over 2 years now. I articled with the firm, and I've been there practicing with the commercial litigation group ever since. My practice includes a variety of things, including real estate litigation, commercial tenancies litigation, construction litigation, employment law, of course. I take on roles advising both employees and employers with respect to employment contract issues and termination issues. I also do a certain amount of fraud litigation, both in the employment context and fraud involving banks and directors and officers of corporations. So they've asked me to come here today and speak to you about employee fraud. And I've prepared a little bit of a presentation. This is somewhat of a longer presentation, and it's geared for a longer presentation. But I'm going to try to move through it kind of quickly and stick to that 10 minutes that I've been allotted. So, start off with the question, first of all, what is employee fraud? What are we dealing with exactly? And I've taken a definition here that comes from the Association of Certified Fraud Examiners. And they say that employee fraud is the use of one's occupation for personal enrichment through the deliberate misuse or misappropriation of the employing organization's resources or assets. So that's a definition for you. What does that really mean? I've given a few examples here of employee fraud. These are some common types that we see and that come up in the case law. So falsifying expense reports, very common. Taking sick leave when one isn't actually sick is another example. The third example that we're familiar with, hopefully not personally familiar, but we've all heard of before, is accepting bribes or kickbacks. And the fourth is straight up asset misappropriation, stealing, putting your hand in the till and taking money. And so is this a serious problem? Well, according to the Certified General Accountants Association of Canada, it is a serious problem. It's a $3.2 billion a year problem in Canada. And according to the Association of Certified Fraud Examiners, it's costing about 5% of annual revenues. So I think there are two issues that come up when we look at this. The first is if you're dealing with employee fraud, when do you have cause to dismiss an employee? Some of my colleagues have been talking a little bit about wrongful dismissal. And as I mentioned, I deal with wrongful dismissal. The employer doesn't want to end up in a wrongful dismissal situation. The second issue, especially if a significant amount of money has been lost, is of course recovery. So I'm going to try to move through both of these topics. Ultimately, on the issue of dismissal, the fact is that an employee has a duty of good faith and fidelity to their employer. Where they breach that duty, they may be dismissed by the employer for cause. Now, I raise this as an important topic because when we think of fraud, we think of dishonesty. Not all dishonesty gives rise to dismissal for cause. Falsifying expense reports has been held in numerous cases to be cause for dismissal. So, for example, if I submit an expense report to my employer that says I'm taking clients to dinner when I'm not actually doing that, or if I'm submitting an expense report with forged receipts, or, on the other hand, just increasing my mileage a little bit to skim a little off the top. These are cases where employees have been dismissed for cause. Similarly, taking sick leave. If I call in sick, but it turns out that I'm going to work at another law firm and spending my time there while getting paid by my employer, I might be dismissed for cause. Now, the clearer cases are, of course, in terms of bribery and kickbacks. Or are they? In these cases, employer policies, end up being crucial. For example, you have the case of me saying to a supplier, okay, I'll agree to give you business and you give me half your profits. Well, maybe that's a clear case. But what about the case where, I'm talking about a supplier of light bulbs or something that's a little bit less important, and someone agrees to give me a free TV? Here's a case where there may or may not be cause made out. It may or may not be something that can be legally classified as fraud, and it's important to be aware of the issue. If you're not aware, and you're not sure what to do, of course, you may want to speak with a lawyer. The other issue, of course, when we talk about, again, I say someone being caught with a hand in the till, well, what about stealing? Well, not all theft is sufficient to give rise to dismissal for cause. And I've pulled up an example of a case here where an employee was admitted to having stolen a couple of bolts from his employer. Well, a couple of bolts is one thing. Maybe I walk out of the office at the end of the day and I've got a couple pens in my pocket because I forgot they were there. Maybe it's theft, but it's so minor no one cares. But what if I'm taking a box of pens, or I'm taking a package of paper? What if I, walk out with the printer that's next to my desk? At some point it crosses the line, and at some point it does give rise to dismissal for cause. Now the bigger issue, of course, arises, again, the hand in the till, someone actually taking money from their employer. Sometimes the amount can be significant. Large thefts, there's less of an issue, of course, in terms of cause for dismissal. And the issue that we turn to there, of course, is not simply do you have cause to dismiss the employee, but the reason you might call your lawyer in that situation is because you realize that you've lost some money and now you don't know exactly what to do about it. So what do? First, there's the issue as to whether you confront the employee at all. Do you walk straight up to them and say, you're fired, you're out of here? And then do you take legal action? And if so, what type of legal action? Criminal, civil, what? Confronting the fraudster in this case can be fairly significant. And the reason is simply this. If the employee who has fraudulently misappropriated funds or assets from the employer is tipped off at an early stage, what are they going to do? They're going to take steps to cover their tracks. They're going to take steps to hide assets so that you can't get at them eventually. Okay? So, and I appreciate it moving through the slides quickly here, but I think the important bullet from this slide is simply to control the flow of information to that employee. Who do you involve? Who do you involve from your workplace? And what steps can you do to make sure that the employee doesn't run off and become all of a sudden impecunious? So, what do we suggest as lawyers? Well, the first issue is, of course, documenting the fraud. You want to get everything down that you possibly can. You want to make records of everything. And where you are not able to make your records sufficiently, your lawyers have a few tools in their legal toolkit which they can use to assist with documenting the fraud. The second is, of course, you want to locate and you want to freeze assets. Again, if someone has defrauded you, they want to keep their money, and they don't want to give it back to you, and so they're going to take steps to make sure that doesn't happen, likely. And the last is, of course, to actually get what money one can back from the fraudster. So in terms of documenting the fraud, I've mentioned up here a particular recovery mechanism referred to as a Norwich order. And a Norwich order is a type of order that is, I believe, intended to deal specifically with fraud cases. It's a pre-action discovery mechanism, which means that it's something that can be obtained before you've actually commenced litigation against the fraudster. And it will allow you to get information from third parties. The information is to identify the fraudster, to document the fraud, and of course to provide any necessary information with respect to tracing misappropriated funds or assets. They're typically granted against banks because we want banks' records. Once we know that money has flowed from an institution or a company to a fraudster into a bank account, we want to be able to trace it as best we can. Okay? Now, I've set out a test here, but again, I'm going to move through this rather quickly. The second, and this is another sort of extraordinary tool that is available only in limited circumstances, and this is referred to as an Anton Pillar order. Now, an Anton pillar order is what we tend to think of as a civil search warrant, where you and your lawyer can actually show up at a person's business or home and search and seize evidence in order to document the fraud or to gain evidence that's necessary to be used in the litigation later on. Now, in order to get an Anton pillar order, and this is a process that courts control very strictly, you have to be able to show, and it's often difficult to be able to show, that the evidence is likely to be destroyed if one is not granted the order. Now, so you've documented the fraud, you've made careful notes of everything, you've spoken to your lawyer about whether I confront this person, what do I do, what are my next steps. You want to make sure that the money doesn't somehow dissipate or float away. And the issue with respect to fraud in particular is that, again, this person has already stolen your money. They're not likely to want to give it back, and it is likely to somehow be dissipated. Particularly given the statistics, and I haven't included them in the slides here, that suggest that, well, what happens to this money? Drugs, gambling, high living, there's a chance that it may not be there to recover at the end. So you want to take the steps that you can to ensure that it is. And there are a variety of tools that we can use to sort of freeze assets or freeze funds. The first that I've mentioned here, and it's a term you may have heard before, is a Morave injunction. This can be done initially without notice to the person and served on the relevant parties, whether they be banks or other people who are involved. The court may also provide an order for custody and preservation of assets, where it's likely that if someone doesn't seize the asset, it's going to go somewhere else. Certificate of pending litigation, if you believe that the funds have gone into property, i.e. land, which will allow you, of course, to give notice to all the world that there's a proceeding pending that puts an interest in land in question. And the last I've mentioned here is what's called a Bank Act freeze, and this is where you actually commence a proceeding that names the bank as a party and serve it on the bank at the branch, and the banks are familiar with this, and they know that they've got to put a freeze on all deposits in the account that's named in the document by which you commence that proceeding. So, now that you've frozen your assets, documented the fraud, you've taken what steps you can to make sure that nothing's going to dissipate, you want to take some steps to actually get it back. Now, an employee who handles an employer's money occupies a position of trust, and the courts say they have what's referred to as a fiduciary duty. If they steal the money is impressed with the trust, and any use of that money other than giving it back to the employer is going to be inconsistent with the purposes of that trust. So for the purposes of recovery, it's very important that we are aware of what we can do in terms of making trust claims against money, because trust claims give rise to what are referred to as tracing orders. Okay? So that money may, as I suggested earlier, be used to purchase property. It may be used to purchase other assets, and it may also flow to third parties. In certain cases, if I take money from my employer, maybe I give some of it to a spouse or to a child or to a friend, where that third party has knowingly received the money. They may be liable to the extent that it has flowed to them as well. So you're pursuing, in this case, not just the fraudster, but you've got another target of potential recovery. Now, of course, this topic is not just responding to employee fraud, which is something that we deal with in our practice, but it also has to have the practical element. Talked about a variety of court orders. What do you do in terms of prevention? Now, largely, I believe it's an accounting issue, and it's an issue of internal controls. But I've included just a few bullet points here in terms of suggesting what may be done to not land ourselves in this situation in the first place. And the first one is obvious. It's simply education. Being aware of the problem is, of course, the first step to dealing with it. Being aware that it's costing Canadian businesses $3.2 billion a year, I find is staggering. So how do we make sure that we're not those businesses that are losing money? Maintain an interest. Accounting procedures. Again, largely there is an accounting issue, and conducting frequent reconciliations, of course, is something that you can discuss with your accountants and may help to at least catch problems earlier rather than later. Anti-fraud training, of course, again, that's part of education. Fraud reporting mechanism is something, especially if you're dealing with larger institutions, having things such as whistleblowing hotlines, of course, is something that would be suggested. Fidelity insurance, of course, is something that's available. Fidelity insurance can protect, or at least indemnify to some extent, against a case where you have been the victim of fraud or criminal activity. And the last is, again, hopefully fairly straightforward, asking questions. I think fraud detection is generally considered to be somewhat adversarial in nature. The statistics suggest that those who commit fraud are those who we put in positions of trust. And so, again, you've got to question the position of trust, and you've got to question the individual in order to make yourself aware of the potential for fraud. And that should lead us to my last slide, which is I am around for any questions and happy to discuss with you. Thank you.